Yes, let us start. Okay. So very good afternoon. Good afternoon. So yesterday I think we have started preamble and we discussed some of the important key terms associated with that of the preamble. Like we started with that of liberty, and then previously we have seen like what is a complete text of the preamble, like, and the characteristics of the preamble, like sovereign, socialist, secular, democratic and republic. And then also we have seen the objectives: justice, social, economic and political, liberty of thought, expression, belief, faith and worship. Today we will continue with the equality. Okay. So equality is basically, it mentions about two important things: equality of status and equality of opportunity. Equality of status and as well as equality of opportunity, which means that everybody has to be treated equally and the status of everybody has to be same. So there are certain provisions in our constitution, like for example fundamental rights. Fundamental rights from article number 14 to 18 of the constitution. Okay, article number 14 to 18 of the constitution provides us about this equality related provisions. Like for example, article number 14 deals with equality before the law. Article number 15, so the state shall not discriminate anyone on the basis of certain grounds. Article number 16, so the state shall not discriminate on certain grounds in the case of public employment. And finally article number 17, abolition of untouchability. And article number 18 deals with abolition of titles. All these provisions we will discuss in detail in the later on classes. Okay, as of now what we have to understand is that these provisions will enable us to ensure that equality is maintained. Okay, and also at the same time, so that opportunity is provided. The same thing we have written the content here. Equality of status refers to equal regard and respect to all individuals regardless of their background, their social standing and economic conditions. Whatever their economic conditions is, to whatever the caste they belong to, whatever religion they belong to, that doesn't matter. So okay, so we will provide that so-called equality to those particular people. And then it also implies the absence of any forms of discrimination based on caste, creed, color, religion or socio-economic status, ensuring that all individuals are treated equally in the eyes of the law and as well as society. I hope you are clear with these particular points. If that is the case, the same applies equality of opportunity. For example, we have something called public employment. In the case of public employment, is there any discrimination? Is there any discrimination that you are not eligible? No such discrimination is there. So that means everybody will be treated equally if in the case of public employment. That means you are providing to everybody equal opportunity. So, and also it means that, but however, we are providing some reservations to the backward classes. So that is not comes under this particular discrimination, that is actually positive discrimination. That is also called as affirmative action. Okay, so we will discuss that in detail. So therefore that is all about equality of opportunity. This entails providing equal chances to everyone to develop their skills and talents so that to pursue their aspirations without any unfair barriers or discriminations. So there should not be any unfair practices which are discriminatory in nature. So that deals with all about, it includes like equal access to education, admission to educational institutions and as well as employment in the case of public employment and other resources which are necessary for the personal and as well as professional development. That is all about equality of opportunity. So the first objective is justice. Okay, the first objective is justice, divided into like social justice, economic justice, political justice. Social justice and economic justice together constitutes distributive justice. Okay, and then we have liberty. Is that liberty absolute in nature? Is that liberty absolute? It is not. It is certain restricted. It is applicable to, I mean there are certain restrictions on that particular liberty. Okay, and we have different types of liberty like liberty of thought, liberty of expression, liberty of faith, liberty of belief and worship. And then comes equality of status and as well as brotherhood. Then the final term comes called as fraternity. Fraternity is basically, so the sense of brotherhood, correct? Okay, So that means there should be a sense of brotherhood between the two human Indian citizens basically, okay. So there should not be any spread of hatred against another individual or another community or another section, okay. So there should be, the people have to live in harmony with each other and have to help with one another. That is all about fraternity. So when you read the particular these things, fraternity is basically a key principle in the preamble of Indian Constitution, fostering a sense of brotherhood among all the citizens. Okay. Next, this principle not only is about promoting social harmony, but it is also about ensuring that the nation remains united and as well as integrated. Okay. The other objective of the fraternity is basically the unity and as well as integrity of our country. Okay. To ensure that particular unity and as well as integrity, so we will, this is one of the objectives of the fraternity. And the another objective is ensuring the dignity of the individual. What does it mean by? So the dignity means it's not only right to life, right to life with dignity. That means they should have a respect, so no, they should not be discriminated, so they should have lead a dignified life, respectable life, nothing but. Okay, so that is being assured by this fraternity and preamble as a whole. Okay, fraternity in the context of Indian Constitution involves recognizing and respecting the inherent dignity of the every individual. Okay, so this is the fourth objective called as fraternity. There are only 4 objectives mentioned in the preamble, starting from justice, next one is liberty, next one is equality, and then comes fraternity. Okay, so these are the 4 objectives. And on the first part we talked about what is the nature of our country. For example, like what is the nature of our country? Sovereign, socialist, secular, democratic, and republic. Out of all these 5 words, what were the words which were added later? Secular, and one more word? Socialist. Correct. Socialist and as well as secular were added later through 42nd Constitutional Amendment Act 1976. Even the year and the amendment is also very important. Okay, fine. Then the same thing, apart from the fraternity, apart from assuring the unity, dignity of the individual, it also ensures that unity and integrity of the nation. That means India as a whole should be a single entity. It should be like, it should not be divided into multiple these things. Okay, so like for example regionalism, communalism. So all these, what it will do, it will break the India into multiple parts. That should not happen, and the objective of this preamble is to ensure that that unity and integrity has to be maintained. And again, which word was added later? In unity and integrity, which word was added later? Is it unity or is it integrity? Integrity, correct. So socialist and as well as the secular and then integrity. These 3 words were added later on through the Constitutional Amendment 42nd one. Okay. Then comes a very important question. Is the preamble part of the Constitution? Is this preamble, which is basically considered as a 4-word or basically considered as a preface or introduction to the Constitution, is it part of the Constitution or is it completely separate? Part of the Constitution or is it separate? So this was the question. Who has to answer? Whenever something has to be interpreted in the Constitution, it is the Supreme Court which will answer. Okay, this question will be posed to Supreme Court and Supreme Court will answer this particular question. Not only this question, anything with respect to Constitution. So something, a question has to be asked, then immediately it is a Supreme Court we have to ask, and the same question was posed to the Supreme Court as well. Sir, is this preamble that was drafted and it is taken from which Constitution? The idea of having a preamble is taken from American Constitution. The content that is there inside the preamble is taken from the content inside the preamble is taken from the Indian Constitution. That is fine. Objectives resolution. Whatever that is there in objectives resolution in the year moved by, who moved it? Who moved the objectives resolution? Pandit Jawaharlal Nehru, correct. Pandit Jawaharlal Nehru has moved this objectives resolution, and the same thing was incorporated into the preamble of our constitution. Fine. If that is the case, the same question was asked, is the preamble part of the constitution or not? Then in the first important case is the 1960 Berubari case. Berubari case. Okay. In this Berubari case 1960, Supreme Court has held that preamble is not a part of the constitution. Okay. In which of the following cases did the Supreme Court held that the preamble is not a part of the constitution? It was the Berubari case which took place in the year 1960. In this particular case, the Supreme Court has held that no, preamble is not a part of the constitution. Okay. And then the second important point it said is that it is basically key to the constitution. Okay, fine. Key to the minds of the framers of constitution. So this preamble is basically like a key. Key to what? Key to the minds of the constitutional makers. So that means what was their thought process, how they thought, how they envisioned that constitution of India should be, that all those particular objectives will be explained through preamble. That means if somebody reads the preamble, they can understand what is the objective of this constitution, like what is about the country, what are the objectives, and when this constitution was adopted. When this constitution was adopted? By the Constituent Assembly. When it was adopted? That was by the country, it came into force. By the Constituent Assembly. On that particular day we celebrate Constitution Divas or Constitution Day also. November 26th, 1949, correct. On this particular day the constitution was adopted. True. So therefore, the first important question was posed to the Supreme Court of India, is the preamble part of the constitution or not? And it was in the Berubari case 1960, Supreme Court has held that preamble is not a part of the constitution. And the second comment that it has made is, preamble is just key to the minds of the framers of the constitution. So now UPSC has framed a question exactly on this point, where it has asked that which of the following parts of the constitution is considered as a key to the minds of the framers of the constitution? A, preamble; B, fundamental rights; C, directive principles; and D, fundamental duties. The answer is preamble, correct. Then again the same question was asked later on in the year 1973. Okay, the most and famous case called as, correct, Keshwananda Bharati case. The same question was again asked to Supreme Court, sir, is the preamble part of the constitution or not? In Berubari case, it was already told that preamble is not a part of the constitution. Now if you want to review it, you can review it. Then in Keshwananda Bharati case, so the judges have stated that this so-called preamble is part of the constitution. So this so-called the preamble is part of the constitution. That means it can be amended just like you amend any other provisions of the constitution. Okay. So therefore, now as of in 2023, therefore, what was the status of this preamble? Is it part of the constitution or not a part of the constitution? Is it a part or not a part? It's a part of the constitution. Now when this is, for example, this is the year 1971, then when I say, is this preamble part or not? Not a part, because it was 2 years later in Keshwananda Bharati case that they have stated that preamble is not a part. With respect to this, whether part or not, you have to know these two important judgments. Okay, 1960 Berubari case, where it stated that preamble is not a part, and they made a comment, it is key to the minds of the framers of the constitution. Then came 1973 Keshwananda Bharati case, where it stated that preamble is part of the constitution. Okay, and in this Keshwananda Bharati case only, something was brought up called as, yesterday we talked about, right? Correct. The basic structure of the doctrine. In which of the following Supreme Court cases, Supreme Court has innovated this doctrine of basic structure? It was innovated in Keshwananda Bharati case. They'll give the options like A. Berubari case, B. Keshwananda Bharati case, C. Golaknath case, D. Indira Sahani versus Union of India case. So the answer is Keshwananda Bharati case. There can be a chances where they can ask you about chronology as well. Arrange these landmark Supreme Court judgments in a chronology or in an order, so that you should also know the years as well. It was Berubari in 1960 and in Keshwananda Bharati it is 1973. Okay. In the year +3, it was in 1976. Which constitutional amendment came? 42nd constitutional amendment came. Okay, and it made many changes to the constitution. Since we talked about only preamble, so we are concerned only with the amendments to the preamble. What are those three words? Secular, socialist, integrity. Those three are the words which have been added. So the same thing now we will read in the slides. You can read it. The status of the preamble as a part of the Constitution of India has been clarified and established through the landmark Supreme Court judgments. Okay. In the Berubari case, 1960, the Supreme Court initially held that the preamble is not a part of the Constitution, and also it made a comment that it is just a key to open the minds of the framers of the Constitution. Just know that what we have learned. Then, however, this view was overruled. Overruled means when you say the opposite, like if you strike off that particular say and you say the new thing, that is overruled by the Supreme Court in the Keshwananda Bharati case 1973, where it was definitely established that the preamble is an integral part of the Constitution. Okay, Nandi? So this particular, whether preamble is part of the Constitution or not, you should tell these two things. Earlier in Berubari, not a part. But however, they made a comment that it is key to the minds of the framers. But point number 2, in 1973, in Keshwananda Bharati case, this particular preamble is basically declared as an integral part of the Constitution, and it can be amended like any other article of the Constitution. Clear? Which objective provides you the sense of brotherhood? Fraternity. Correct. Okay. So which objective provides you that in the public employment there should not be any discrimination? Which objective? Equality of opportunity. Okay. Then I can express anything, my choice. If I want to criticize government, I will criticize. If I want to appreciate the government, I will appreciate. Which objective? Liberty. Particularly which one? Expression. Liberty of thought. Second one is liberty of expression, right? That's what we are talking about. Then comes the next question. The question says, first question we handled is the preamble part of the Constitution or not? Now the second question is, can the preamble itself be amended or not? Can it be amended? It can be amended? It's a part of the Constitution, so therefore it can be amended. And how many times it was amended? Only one time? Because we have seen only once, right? Correct. So the first answer is yes. The preamble can be amended like any other article of the Constitution because it is also an integral part of the Constitution. Number 2, how many times it was amended? Only once it was amended. And that basically, when it was amended? 42nd Constitutional Amendment Act 1976. So these are basic facts, Sunday. Okay, you should just like that tell, and these need to be on your fingertips. Okay, na? Then the same thing we have written here. The preamble to the Indian Constitution can be amended because it is a part of the Constitution. This was affirmed in the landmark judgment of the Keshwananda Bharati case by the Supreme Court of India, which stated that every part of the Constitution, including the preamble, could be amended provided the basic structure of the Constitution is not destroyed. Okay? I hope you have not understood this point or understood. In which case the doctrine of basic structure was brought up? In which Supreme Court case the doctrine of basic structure was innovated? Yes, basic structure. The doctrine Keshwananda Bharati case, correct. Keshwananda Bharati case of 1973, the basic structure was introduced. Okay, so whatever the amendments that you are making to the Constitution, it should not violate this basic structure. The basic structure should not be disturbed. What is basic structure and its analysis we will carry out in the foundation level. We will do all those particular things. Okay. So therefore, what is your conclusion? Can the preamble be amended?
Yes.
Yes, because it is also a part of the constitution like other provisions, it can be amended. As per the status now, how many times it was amended? Only once. In the year 1976. Through which amendment? 42nd constitutional amendment, correct. Yeah, the same thing that we have written here, that the preamble has been amended only once. UPSC generally asks you in such a way that the preamble, like in Roman number 1, they'll give something associated with preamble. Number 2, they say that the preamble was never amended, but however it can be amended. Okay, first point says that not a part of the constitution. Okay, so the first option says that not a part of the constitution, and the second Roman number says that never amended, but it can be amended. Are these two statements correct or wrong? Wrong. Or either one or both are wrong? Both are wrong, because it is a part of the constitution and it can be amended, and it was done already once. The preamble has been amended by the 42nd Amendment of 1976 during the emergency period. This amendment made 3 significant changes to preamble. So the word sovereign was expanded to include socialist and secular, making India a sovereign, socialist, secular, democratic and republic. This is the status of our country post which year? This is the status of our country post which year? 1951. Which? 1976, correct. 42nd Amendment Act only introduced it, right? So that means after 1976 only, this is basically the status of our country. So, yes. And then the phrase unity of the nation was also changed to unity and as well as integrity of the nation. Yes, you are clear? Done. Then, next question comes. Is the preamble the source of the power to the legislature or not? That means, do the preamble gives the power to the parliament to make any law? This was the question. Any comments on it? Is it a source of power or not a source of power? So that means by using the preamble itself, can the parliament can make a law? Correct. So yes, the preamble is basically not a source of power, or not only source of power, it doesn't even limit the parliament also. So that means either point number 1, it will not give any power to the parliament to make a law, or it will not impose any restrictions on the parliament as well not to impose any law. Preamble is just a summary document. Preamble is just an executive summary of our constitution saying that what we want to achieve, what this constitution want to achieve for this particular country. That is what is the preamble. The source of power or not is the answer. You can see that. The preamble to the Indian constitution is not the source of power. So these words seems very similar and easy and as of now, but in exam perspective if you start reading it, so they will tweak the words in such a way that they'll make us believe that that statement is true. Okay, our basics need to be very clear. So so the Indian constitution is not the source of the power for the government. Instead it serves as a guiding principle which outlines the objectives, values and ideals upon which our constitution is based. So all these things we are already aware of, that constitution basically provides us the objectives and values and ideals as well. Ideals like justice, social, equality, political, all those important things. The preamble sets forth the fundamental purpose and guiding principles of the constitution such as liberty, equality and as well as fraternity. Yes. Then, up till now we have answered 3 questions. Is the preamble part of the constitution or not? Number 2, can the preamble be amended or not? Number 3, gives the power to the legislature or parliament or not? Okay. And finally the 4th question, is the preamble justiciable or not? What is justiciable? Justiciable means enforceable in a court of law. For example, on day 1 we talked about fundamental rights. Okay, so that means whenever a person's fundamental right is violated, can they approach any court? They can approach Supreme Court. Under which article? 32. High Court under 226. Okay, under Article 32 they can approach Supreme Court, and under Article 226 they can approach High Court. So that means it is justiciable, it is enforceable. Whenever there is any mechanism through which if you can go to the court in enforcing it, that is called as justiciable. If you cannot go to the court saying that this is violated, that is violated, then that is what is not justiciable. Now the question is, can we go with this preamble that in preamble they said that equality of status, everybody has to be equal, and liberty, for example, we have, then but there is a huge gap between rich and as well as poor, isn't it? Now you read the polity and you thought that the preamble says that this gap has to be bridged, okay, but now you went to the, can you go to the court based only on preamble? Correct. So based only on preamble you cannot go to the state. Can I say that it is basically? No. Correct. It is non-justiciable. You have to use these keywords, and be it in your mains or in the prelims as well, you can see these questions, okay, these words. They will not simply say you that the preamble cannot be enforced in a court of law. They will not say that. They will say that the preamble is non-justiciable in nature. You should understand that non-justiciable means not enforceable in the court of law. When I say fundamental rights, are they justiciable? Yes, they are justiciable. Okay. So you can, let's see what is the options. So therefore the preamble to the Indian Constitution is non-justiciable, which means that its provisions are not enforceable in a court of law. They are just basic objectives. They are best introduction to the Constitution, and they lay down the ideals and aspirations which guide the Constitution. These are the probable questions in which they will ask you on preamble, and okay, na? For which you need to be very thorough with these points. Then, now let us see the previous year's questions. Now it is high time that you should answer. Now the question says that what is the exact constitutional status of India on 26 January 1950? What is the exact status? Is it a democratic republic? Is it a sovereign democratic republic? Or is it sovereign secular democratic republic? Sovereign socialist secular democratic republic? D, na? Okay, then? What is your answer? Not last one? 76, post 76 that has been added, so you can outrightly eliminate that. Is it democratic republic? You mean to say the first one? Or sovereign democratic republic? See how confusing it is. Okay, we feel that we know the things, we feel that which words were there, which words were not there, but the moment you are coming to questions, B. Two. And integrity. In that, if you remove this socialist and secular, so this particular option will come. So yes, that is the answer. Okay, but however, if you say that what was the constitutional status on instead of 1950, if they say 1976, then D is the answer. You should make that distinction. Okay, yes. Next, the same thing that we have written here. So that in the year January 26, 1950, India became a sovereign democratic republic, and later on these ideals have been added, amended through 42nd Constitutional Amendment Act, everything the same story that we already know. Okay. This one. The preamble to the Constitution of India, is it a part of the Constitution but has no legal effect? Not a part of the Constitution and has no legal effect either. A part of the Constitution and has same legal effect as any other part. A part of the Constitution but has no legal effect independently of other parts. Yes. Okay, it is basically a part of the Constitution but has no legal effect. Okay. So for sure you can say that not a part of the Constitution. This is wrong, right? Okay. Next. Is it basically a part of the Constitution but has no legal effect? A part of the Constitution but has no legal effect independently of other parts. Please be very clear with the options. Isn't D, correct. It is a part of the constitution but has no legal effect independently of other parts. If you combine the other parts as well, the other articles as well, then immediately preamble will also gain the prominence. Even we can state the judgments in the preamble as well. That means the preamble per se will not have any legal effect. When you combine it with other parts, it can have the legal effect. Therefore, preamble is basically a part of the constitution, and the next one is it has no legal effect independently of other parts. Yes, that's what we have written here. The correct answer is basically D. The preamble to the Constitution of India is a part of the constitution, but it has no legal effect independently of the other parts. Yes. Now this one. Which of the following objectives is not embodied in the preamble to the Constitution of India? So these are the questions and 2023, 2022, 2021 నుంచి తీసుకున్న questions అన్నమాట ఇవి. Okay. See, that's how they are asking the questions on preamble. Which of the following objectives is not embodied in the preamble to the Constitution of India? Liberty of thought, economic liberty, liberty of expression, liberty of belief. Economic liberty? Correct. It is the economic liberty, because in preamble if you see liberty, we have only thought, expression, faith, belief, worship. There is not mentioned in the preamble. Okay, so therefore here the answer is economic liberty is not embodied in the preamble. The same thing we have written. The preamble to the Constitution of India outlines the fundamental principles and objectives which guide the nation. It includes the ideals of justice, liberty, equality and fraternity, but however the specific mention of the term called as economic liberty is not present in the preamble. Okay, just it takes you 2 seconds time to answer that question, Andy. Okay na, just like that. Now can you answer this one? Okay, the minds of the makers of the Constitution of India is reflected in which of the following parts? Preamble. This is how they will ask. Now can you tell me in which case this particular comment has been made? In which case this comment has been made by the Supreme Court? Berubari case. Okay, Berubari case 1960. In that particular case, so Berubari case 1960. Berubari is basically a place or a territory in West Bengal and okay, the same thing. The minds of the makers of the Constitution of India are primarily reflected in the preamble. Can you answer this one? One of the implications of equality in society is basically the absence of ideology, privileges, competition, restraints. Restraints? Privileges? Absolutely correct. That was privileges. Why? Because in equality what happens? Everybody is equal. Everybody should have equal status and equal opportunity. What does it mean by equal status? Any section should not enjoy any special privileges. Okay, so that is what is the privileges is the answer. For example, if the restraints means, if the question is like instead of equality, if they say liberty, then if they say liberty, then it is basically the restraints. Absence of restraints is basically the, we will have the liberty. Okay, the same thing we have written here. Equality in status implies absence of the privileges, because this is the privileges only which typically denotes the special rights, advantages or immunities granted to the certain individuals or groups. Yes, can you answer this question? First one, Paka, yes, correct. Preamble can be amended and it has been amended only once and it was done by 42nd amendment, correct. The same thing, yes, it can be amended and has been amended by the 42nd Amendment Act only once. Yes, okay. This is all about preamble. I hope you are very clear, isn't it? Point number 1, the preamble is basically an introduction or a preface to the constitution. Number 2, the idea of having a preamble is taken from the American Constitution. Number 3, so the content inside the preamble is taken from the Objectives Resolution passed by Pandit Jawaharlal Nehru and passed in the Constituent Assembly in 1947. Okay, that became a modern day preamble. Okay, so then the next important thing we have talked about is what is the exact text of the preamble. So we the people of India, and we mentioned about characteristics. 5 characteristics: sovereign, socialist, secular, democratic and republic. And then we have 4 objectives: justice, liberty, equality, fraternity. So on justice again, social, economic, political. Liberty of thought, expression, belief, faith, worship. Equality of status and opportunity. And fraternity, ensuring the dignity of the individual and as well as unity and integrity of the nation. And finally the last part talks about when the Constituent Assembly has adopted it. So in this particular, on this 26th November 1949, we do hereby adopt, enact and give to ourselves this constitution. Then once that is done, we have taken talked about some important points, like for example point number 1, can the preamble is part of the constitution or not? It's a part, right? Yes, it is a part, and it was said by in Keshwananda Bharati case 1973. Second one is that preamble can be amended, as it can be amended and can be amended only once, 42nd Amendment 1976. Point number 3, is the preamble source of power? No, the preamble per se is not the source of power, it is just the introduction. And finally point number 4, is it justiciable in nature? No, the preamble is not justiciable in nature, it cannot be enforceable in the court of law. Okay, so therefore preamble is a part, and it is basically, it will not have any legal effect independently with the other parts. That's it about preamble.